is an appeal in the matter of a taxpayer and the Commissioners for HMRC.
Yes, Mr. Kessler.
Thank you, my Lord. As this is a public hearing and the live streaming is on, perhaps I could start just to remind any members of the public here or listening to us on the live streaming that there is an anonymity order in this case, which says that neither the identity of the appellant nor the identities of members of the appellant's family may be disclosed. The reason for this is to secure the proper administration of justice and protect the taxpayer's vulnerable relative.
Yes, well, there's no need for names to be mentioned.
There's no need for names to be mentioned at all.
I don't think the names are actually in the bundle, so I don't think.
We might find it difficult to mention them even if we did. But there may be people who could identify from the facts who the names are and make those guesses.
All right, well, thank you for mentioning that.
Good. So the issue in this case is whether the taxpayer was resident in the United Kingdom for tax purposes. The test of residence is called the statutory residence test. It was introduced by the Finance Act 2013. This is the first case on the statutory residence test that we have, and so far the only case that there has been. The legislation is set out in Schedule 45 of the 2013 Act, which has 61 pages in the bundle. But in this case, we're only concerned with one paragraph of that schedule, which is paragraph 22. I will turn to my skeleton, if your lordships have it, which is tab 12.
Yes.
In paragraph 1, I set out the background. I needn't repeat that, but I'm pleased to say there is a great deal of common ground between the parties. Moving to section 2 of my skeleton, the only issue in the appeal is whether the 6 days that the taxpayer was present in the UK in 2015-16 come within the terms of paragraph 22, subparagraph 4. If they do, they are ignored for the purposes of counting days, and therefore she would not be UK resident. If, on the other hand, they don't fall within that paragraph, that would just tip her over to the number of days to make her UK resident.
Yes.
The paragraph itself, we should read briefly at the bottom of page 2 of my skeleton. 2.2, the second case where a day's presence is disregarded is where A, P would not, P standing for person, P would not be present in the UK at the end of the day, but for exceptional circumstances beyond P's control that prevent P from leaving the UK. And B, P intends to leave the UK as soon as those circumstances permit. One can identify in that short paragraph 5 separate conditions, which I set out in 2.3 of my skeleton. This is all common ground. The circumstances must be exceptional. The circumstances which are exceptional must be beyond the person's control. Thirdly, the person would not be present in the UK, but at the end of the day, but for those exceptional circumstances. Fourthly, the circumstances prevent the person from leaving the UK. And fifthly, the person intends to leave the UK as soon as those exceptional circumstances permit. Those 5 conditions we say are self-evident. They follow just from reading closely the terms of paragraph 22.4.
Yes.
At 2.4 of my skeleton, I say it is common ground, and it has always been common ground. No need to slip here. That it's always been common ground that conditions 3 and 5 are met. That was common ground right from before the case went to the First Tier Tribunal. Not condition 2. That is, it has never been contested at 2.3.3, the person would not be present in the UK at the end of the day, but for the circumstances, though it is contested whether or not they were exceptional. And 2.3.5, it's always been agreed that the taxpayer intended to leave the UK as soon as the circumstances permit, although it's contested whether or not they were exceptional. It is now common ground that 2.3.4, that the taxpayer was prevented by the circumstances from leaving the UK. There was formerly an issue as to whether what we meant by prevent and whether or not she was prevented. It's now accepted that she was prevented, although it's still in debate whether or not what prevents her was exceptional circumstances or something other than exceptional circumstances. As to the second condition, beyond the person's control, that has never been formally conceded, but there hasn't been a great deal of argument about it. Because if we were to win on the grounds that there are exceptional circumstances, that they prevented her from leaving the UK, etc., the circumstances we're looking at are the illness, the alcoholism of the twin sister, the state of the children, and so on. And these are all circumstances which are self-evidently beyond her control, beyond the control of the taxpayer. So the focus of debate has been whether the circumstances are exceptional, and in the past as to whether or not the taxpayer was prevented from leaving the UK. Now we can focus on the question of whether or not the circumstances are exceptional. One last piece of common ground
So
is...
we don't have to concern ourselves with condition 2. It's beyond the control.
We say not, although my learned friend does have a point on it. Lastly, it is common ground that this case is not a tax avoidance case, that the test of residence does not depend on whether or not the taxpayer is avoiding tax.
When you say it's not a tax avoidance case, what do you mean? One would have thought one could guess that one of the reasons why the taxpayer chose to move to Dublin was because there's a large dividend coming.
One could make that guess, and that may well be correct. But the point is, well, I suppose there are 2 points, my lord. The first point is it makes no difference to the application of the test.
But then it's more accurate to say it does not matter whether it's a tax avoidance case or not.
And the second point would be to debate whether or not what it constitutes quote avoidance unquote if one leaves the United Kingdom to avoid tax.
I would have thought if you left the United Kingdom to avoid tax, it was a case of tax avoidance, but maybe that's too simplistic a view in this.
Well, that takes us to the very interesting and broad question as to the meaning of quote avoidance unquote.
I think if you arrange your affairs so that tax that would otherwise be chargeable is not chargeable, then normally people would say you're avoiding tax. It doesn't mean there's anything wrong with it, or it doesn't involve moral judgments, or it's not a pejorative term. It's just a factual description of what you've done, isn't it? I mean, I entirely accept that this may not matter at all, but I just jibe at the idea that this is not a case of someone taking steps to avoid tax because it looks as if it might have been. Although,
if leaving the United Kingdom to in order not to pay tax is avoidance, then this is a case of avoidance. That would take us to the question of what we mean by avoidance. If quote avoidance unquote means something contrary to the evident intention of Parliament,
well, that seems to be a quite different question.
Then, which is a commonly used definition of the term avoidance, and I don't propose to get into it, but that's the definition given in the leading case, which is R.C. Willoughby. Then one could debate whether or not this isn't a case of avoidance. But
in ordinary
as
language,
said, we needn't go there because whether or not it's avoidance is irrelevant. The question.
Quite a lot of your case depends on saying that some of the words of this paragraph are ordinary terms.
Yes.
And if we are using ordinary terms rather than some technical meaning, then this is obviously a case of tax avoidance. But that has no particular consequences. We simply apply the paragraph and see what conclusions result.
As this is not a point your lordships have to decide, perhaps we should leave the issue there. Because, as your lordship quite rightly says, we're looking at the meaning of ordinary words, and avoidance is not part.
Right.
Sorry, I interrupted you.
In myself, and if I may take things slightly out of order, I will come back to ground 1, which relates partly to, because it relates partly to prevent, which it doesn't now arise. I needn't consider ground 2, which relates to prevent because it doesn't arise. And I can go straight to the heart of the case, which is ground 3 in paragraph 5 of my skeleton, where we contend, the question is the meaning of the word exceptional. The issue is subdivide, and the question here is whether the question is one of law or fact. And this is a short point. It is common ground that exceptional is an ordinary English word. In the Upper Tribunal, we submitted that the finding of the First Tier Tribunal that this was exceptional could only be challenged on Edwards and Bairstow principles. And the Upper Tribunal said, and it's set out here at 5.2 of my skeleton, we disagree. Whether or not the circumstances were exceptional is a mixed question of fact and law. This tribunal cannot interfere with findings of fact made by the FTT unless there is no evidence to that effect. However, whether one or more findings of fact mean the taxpayer's circumstances are exceptional is a question of law. In our submission, it is a question of fact. It remains a question of fact, or secondary fact, one likes to distinguish between primary and secondary facts. In my skeleton, I cite 2 cases to support me in that submission. The well-known case of Brutus and Cousins, 5.4 of my skeleton, where the issue was the meaning of the word insulting. Was this a question of law? Was this a question of fact? And Lord Reed says, I should perhaps just read the second paragraph. The meaning of an ordinary word of the English language is not a question of law. The proper construction of a statute is a question of law. If the context shows the word is used in an unusual sense, the court will determine, in other words, what that unusual sense is. It is for the tribunal which decides the case to consider not as law but as fact, whether in the whole circumstances the words of the statute do or do not, as a matter of ordinary English usage of the English language, cover or apply to facts which have been proved. If it is alleged the tribunal has reached the wrong decision, that there can be a question of law, but only of a limited character, which is the Edwards and Bairstow test, whether the decision was unreasonable in the sense that no reasonable tribunal could reach it. And for good measure, I quote another case to that effect in the footnote, which I needn't read out now. So we are dealing, we say, with a question of fact, other circumstances exceptional, which can only be challenged on Edwards and Bairstow principles. That takes us to the heart of this case, which is ground 4 in paragraph 6 of my skeleton, which is the role that moral obligations may play in what constitutes exceptional circumstances. In order to pursue this, I propose to read firstly a passage from the First Tier Tribunal, and then a passage from the Upper Tribunal. The passage from the First Tier Tribunal would be paragraphs 149, 150. That's tab, if you could help me with that.
It's tab 8.
Tab 8.
Page 94.
Yes, page 94. If your lordship's with me. Paragraph 149. Secondly, HMRC submitted, this is in the First Tier Tribunal, that the exceptional circumstances test did not encompass a person who came to the UK under moral obligation or an obligation of conscience to care for a family member. That may be a spouse, unmarried partner, or a child, or other person. Instead, HMRC argued that the exceptional circumstance test only applied when the person came to and remained in the UK either under a legal obligation or was physically, e.g. to care for their minor child, that's if there is a legal obligation to care for one's minor child, or was physically prevented from leaving the UK, e.g. by the volcanic eruption which made flights impossible. HMRC based their submission on the word prevent, which, so the argument ran, should be construed to as preclude a moral obligation or an obligation of conscience. This is so argued that the word prevent should be given, quote, real teeth.
This is more to do with prevent, isn't it? Which you tell us is not an issue.
It is, but it relates to exceptional circumstances as well, as we'll be seeing if you'll bear with me.
Yes,
With me very shortly. 150, we reject that submission. There's no justification for such restriction in such language. If we find as a fact Parliament intended to avoid injustice in the application of the SRT, that's the statutory residence test, by excluding exceptional circumstances beyond a taxpayer's control, that it would be hard to imagine a more unjust conclusion than that advocated by HMRC. To conclude otherwise would favour the kind of injustice that Parliament intended to avoid. It could hardly have been Parliament's intention to require the exceptional circumstances test to be failed if, for example, a taxpayer thought it necessary to be present because of serious illness at the deathbed or at the deathbed of a close relative. The word prevent can encompass all manners of inhibition, physical, moral, conscientious or legal, which cause a person to remain in the UK. To read in the restriction that HMRC suggests is not an exercise in statutory interpretation, but rather reading words into a statute which are not there. Now, with that in mind, we turn to see how the Upper Tribunal dealt with that point. And I'm turning to paragraph 69 of the Upper Tribunal, tab 4, thank you.
Sorry, I think I misheard you. What paragraph did you say?
69.
Under the heading how the prevent part of the statute.
Yes, exactly.
Yes, okay.
69 refers to the condition. 70, it's absolutely clear from the statutory words that it is the exceptional circumstances which must prevent the person from leaving the UK, and that is common ground. As we've noted, and then it refers to a sentence from the FTT which I've read. And 72, the statutory question, said the Upper Tribunal, is not whether a person is prevented by an inhibition from leaving the UK, it is whether exceptional circumstances prevent the person from leaving. So they're stressing that this is how it relates. Although we're talking about prevent, it also interrelates with the concept of exceptional circumstances, because it's the exceptional circumstances which must prevent the person leaving. They quote the sentence which I read: it can't have been Parliament's intention to require the exceptional circumstance test to be failed if, for example, the taxpayer thought it necessary to be present because of serious illness or the deathbed of a close relative. I pause to say that that sentence does not say that the exceptional circumstances test is passed in the circumstances of somebody who thought it necessary to be present. What they say is it is not required to be failed. It is possible in these circumstances to satisfy the exceptional circumstances test. That is what we say the First Tier Tribunal say and mean in that sentence. But the Upper Tribunal look at it differently, and this is the key passage in paragraph 73. They say this is to reverse the statutory test. We say it is not. They say it is not correct to say, A, because a person generally thinks it's necessary to be in the UK because a relative is ill and dying, then B, exceptional circumstances exist. Well, it is certainly not correct to say if A, then B, but that's, we say, is not what the FTT are saying. Serious, and then, so they've misunderstood, we say, the point of that sentence. But the mistakes continue. Serious illness and death are themselves not exceptional. The former is commonplace, the latter is universal. It's also not, quote, out of ordinary course or unusual, special or uncommon. That's quoting the paraphrase of the meaning exceptional from one of the cases, for a person to have a sense of moral obligation towards a relative. Objectively, commonplace circumstances such as serious illness cannot be converted into exceptional circumstances by adding a moral obligation. Now, one of the errors in that passage is that it ignores the examples of what constitutes exceptional circumstances, which are in paragraph 22.5 of the schedule. Could you please give me the tag?
So it's tab 2.
Tab 2, paragraph 22.
So page 17.
Page 17. Page 17. Thank you. Tab 2, page 17. Paragraph 22.5, this is the only other paragraph, of the only other subparagraph of paragraph 22 which we need to read. It follows 4, and we do need to read it. It says, examples of circumstances that may be exceptional are A, national or local emergencies, such as war, civil unrest, natural disasters, and B, a sudden or life-threatening illness or injury. And incidentally, it says sudden or life-threatening, so exceptional circumstances may include a sudden illness or a life-threatening illness, but the life-threatening illness needn't be sudden to be something which it says may, not must be, but may be an exceptional circumstance. The whole point of, one point of this may be to prevent someone saying, well, illness is common, and therefore illness cannot be an exceptional circumstance. But this is precisely what the Upper Tribunal are saying in paragraph 73. To go back to that.
Yes, so that's tab 4,
Tab-
page 47.
Tab 4, page 47. Serious illness and death are themselves not exceptional. The former is commonplace and the latter universal. Moving on in the same passage, I'm going to read another 3 or 4 paragraphs. The FTT sought to justify its reading of 22.4 by saying Parliament attempted to avoid injustice. However, as Mr. Stone pointed out, the FTT's formulation is incomplete. The formulation is the quote in the page before paragraph 72. Namely, it could hardly be in Parliament's intention to require the exceptional circumstances to be failed, etc. That is incomplete because it makes no reference to the statutory requirement that the circumstances must prevent. We agree with Mr. Stone, Parliament's intention must be established by considering all the statutory words. Well, nobody will disagree with that. And in this passage, the FTT ignored, they say, the final part of paragraph 22, talking about prevent.
So just pausing there,
Yes.
the UT say it's similar to pre-SRT wording. I'm not sure we've got that.
No, I wasn't.
Is it
I'm very
referred-
happy to refer the court to the position before 2013. Before 2013, the test of residence was largely, though not exclusively, a common law test, and there was guidance as to, and in 2 House of Lords cases in the 20s, the House of Lords said that residence was an ordinary English word to be given its ordinary English meaning, and on top of that, there was a certain amount of guidance given by the Revenue as to when somebody was resident or not. And in the course of that guidance, to which I could refer the court if your lordships wish, there is some reference to an exceptional, to day counting and to exceptional circumstances where day counting doesn't
I mean,
matter.
obviously the UT looked at it, it's
Yeah.
clear from
Yes.
paragraph 75. I had a recollection, which may be wrong, that guidance itself referred to illness either of the individual or of a close relative, but I may be wrong.
Sorry, my lady, to interrupt, but it's quoted in the Upper Tribunal's judgment. It's paragraphs 59 and 60.
Thank you so
Paragraph
much.
59 is IR20, paragraph 60 is the replacement HMRC
Yeah.
6.
That's where I
Thank-
must
thank
have
you.
seen it most recently. Paragraph 59
Thank you.
refers to illness of yourself or a member of your immediate family.
Yes.
I'm not sure how relevant that is. The UT certainly looked.
Well,
It's possibly
It's-
relevant
it-
historical context.
it's a historical. It gives some historical context. But the point of the statutory residence test was to set out a clear and comprehensive code of what constitutes residence. So the guidance to be drawn from this is perhaps limited. One can contrast and compare if one finds it helpful, but not too short it would be helpful.
Well, speaking for myself, it does look at, if we look at paragraph 2.2 of IR20 as set out in paragraph 50, that you've got quite a number of the same concepts, exceptional circumstances, beyond your control. And as an example, illness, not confined to your own illness, but illness in immediate family. And if you look at paragraph 60, that's later updated to bring in the word prevent, an illness which prevents you from travelling. Again, not limited to your own illness, but could possibly include illness of somebody else. Do you have a submission as to what it means in paragraph 22.5b? Is it confined to your own illness or could it include someone else's illness? What do you say the position is?
No, what it says is that illness is not exceptional circumstances, it may constitute exceptional circumstances. And it doesn't say illness of either the taxpayer or anybody else, it could be anybody's illness. Just concluding though on the former guidance set out in paragraph 59 of which Melon friends helpfully referred us to. In the first paragraph, any day spent in the UK because of exceptional circumstances has to be a causative link, which takes us close to where we are now. Although in my submission, what we're looking at here is guidance. It's not case law, and it's certainly not statute.
And it only says normally.
And
it only says normally.
Yes.
So there's quite a lot of flexibility built in.
Yes. For instance, it would allow the revenue to say, as they do now by statute, that if one spends a very long period here, we're not going to ignore it. There's a cap on the number of days you can ignore owing to circumstances beyond your control, which is 60 days in the statute. Before there's no formal cap, but normally would allow that sort of approach. If somebody was here all year because of the illness, then the revenue, consistently with the former guidance, could have said, we regard you as resident.
And that's been replaced by a 60-day cap, you said?
Yes, in the statute, yes. In this case, it's only 6 days, so we're nowhere near the cap.
Is it 60 days of residence, or 60 days? Is it 60 days you spent here, or 60 days where you try and take advantage?
You can disregard up to 60 days.
I see.
If owing to exceptional circumstances beyond your control, you're here for 62 days, 2 of those days will still count towards the residence test.
So if you've got, but you could have 45 days which doesn't tip you over, and then another 60 days which are...
No, the 60 is a cap for the whole year. Could you just fish out the section?
Yes.
It's in the schedule.
I'm done 15. So you could you, use up your 45 days, even though you knew that, let's say, your mother was likely to die within the next year. And then when she does die, you can say, well, I've got to be there at the deathbed or at the funeral and invoke exceptional circumstances beyond your control.
If there are exceptional circumstances beyond your control, you could.
So the fact that you've chosen to use up your days knowing that this is likely to happen is just irrelevant, is it? It may not matter on the facts of this case, but I'm just trying to see how it works.
It's certainly not determinative. The First Tier Tribunal distinguished between foreseeability, identified the role of foreseeability in the passage, and in a passage which is not appealed, paragraph 147.
Yes, I mean it's the exceptional circumstances that have to be beyond your control, not the fact that you've gone over the 45 days.
Yes. Perhaps since you've raised the question, let's just look at paragraph 147 of the First Tier Tribunal decision, which is tab 8. Paragraph 147. Page 94. In the context of the present appeal, it was acknowledged that the appellant's twin sister was an alcoholic and had mental health difficulties, and apparently had suffered from those complaints for some time. HMRC argued that because the appellant would have been able to foresee a need to support her twin sister when she took the decision to take up residence in Ireland, this prevented the circumstances from being exceptional. We do not agree. There is no requirement in statutory language for foreseeability or non-foreseeability to determine whether or not circumstances are exceptional. Foreseeability is not the statutory test. It is true that foreseeability, may be an element of exceptionality. So I would go so I say it is something that the tribunal may take into, for instance, may take into account in deciding.
Yes, well, this paragraph seems to
It is
address
not the
the
determining
kind
factor.
of example I was putting to you.
And that, I think, wasn't picked up in the UT at all? No criticism?
No,
of that?
there was no criticism of this passage in the Upper Tribunal, and it is not criticised, I don't think, at least not in the skeleton of my learned friend. That passage may well be common ground. We would certainly say that.
Okay, thank you.
Identifies the role of foreseeability in relation to the exceptional circumstances test.
I think you were going to give us the statutory reference for the 60-day.
So it's paragraph 22(6)(a). And that's the taxpayer page 18.
Oh, I see.
Yes. Paragraph 22(6)(a). For a tax year, the maximum number of days to which there's no apply in reliance to paragraph 4 is limited to 6 days. And then you start counting again.
So you could have 45 days plus 60.
You could have as many days as you're allowed. In the taxpayer circumstances, it's 45, sometimes more, sometimes less, depending on other factors. And whatever those days are, you can add another 60 due to exceptional circumstances beyond your control, which prevent you from leaving, but no more. More than that, that's too bad.
But it's not, as my lord suggested, just being able to add another 15 to take you up to 60. You can add another 60.
Yes.
Yes.
And the number to which you're adding will vary according to the circumstances. In some cases, somebody's resident if they're here for more than 14 days. In other circumstances, more than 45, more than 90, more than 183. There's a sliding scale depending on other connecting factors. So we were looking, before we were distracted by foreseeability, we were looking at the Upper Tribunal. Let's continue with the passage I was reading from the Upper Tribunal. At 76. This is key to the. This is now we're now at the heart of the argument. If your lordship's with me, then at paragraph 76 of the Upper Tribunal decision, we find that HMRC are correct to submit, say the Upper Tribunal, that the FTT erred in law in deciding that the requirement, the circumstances prevented the applicant duty could be met, not that it would be met, but it could be met by a moral or conscious inhibition on the appellant leaving the UK. Or we would say that the circumstances which were exceptional could include the moral or conscientious inhibition. We consider, 77, the FTT was similarly incorrect to say moral obligations and obligations of conscience can qualify as exceptional circumstances and may be strong enough to prevent a taxpayer by leaving the UK. In this passage, the FTT went further, holding that moral obligations taken alone can constitute exceptional circumstances, irrespective of any other objectively assessed facts. In practice, one would always assess the facts in the context, we would say, in the context of all the circumstances. I'm not quite sure that the FTT intended to say anything different, but it doesn't matter. But this is a passage to which we object. Moral obligations are not themselves exceptional. They're shaped by society and subjective feelings of an individual. Where a person feels a moral obligation towards a relative whose circumstances are exceptional, the moral obligation does not form part of the circumstances. Accordingly, a person is not prevented by exceptional circumstances from leaving the UK, he is prevented by his sense of moral obligation. We say that the circumstances meet all the relevant circumstances, which may include a moral obligation. And in the last sentence, one has a false dichotomy between a person prevented by exceptional circumstances and a person prevented by a sense of moral obligation, because one can be prevented by both. And it is wrong to say, to limit the concept of circumstance, exceptional circumstances, to the circumstances of the case other than the moral obligation. As Mr. Stone pointed out, a person who comes to the UK because he thought it necessary to be present is able to do so. Well, this is true. However, if the person has used up his available UK days, the extra visit will cause him to be UK resident for tax purposes. And this, on my learned friend's argument, would include coming to care for a spouse, an unmarried partner, an adult child, or indeed a minor child, unless one can conjure up a legal obligation.
So you do have legal obligations to care for your minor children, don't you?
My lord, that would take us to questions of family law, to which on which I would hesitate to comment. As a general principle, no doubt, but whether those obligations, legal obligations, would require one to be come in person to care for the child, I very much doubt. In the case of a foreigner, one would be looking not at UK law but at foreign law. But I don't see why a foreign father couldn't send a Mary Poppins across to look after the sick child. May do a better job than the father. So it is assumed without any examination that the law of every country requires a father a parent to attend in person. Indeed, the father may say to the mother, "You go." Mother may say to the father, "You go." Either of them could go.
Just to be clear what you're saying, paragraph 79, you say is wrong,
I do.
and it's wrong because what they say in 78 is wrong. Is
Yes.
that- Yes.
Yes, exactly. It is wrong to say the circumstance of the case do not include the moral inhibitions.
When they talk about moral obligations, are they talking about, or are you talking about those which are commonly shared in society, so that it is quite common for people to feel moral obligations towards close relatives, but not towards strangers or pets? I mean, it wouldn't be good enough, would it, if somebody said, "Well, I just had to be there because my pet tortoise was ill"?
It would be a question for the tribunal to decide whether these were exceptional circumstances which forced the individual to be in the UK. And in the hypothetical case of somebody who said, "I needed to come to care for my dying pet," the tribunal is likely to say, "No, those were not exceptional circumstances which forced you to be here." And it is not for the individual to say, I thought these circumstances were exceptional, and therefore I had to come. It is for the tribunal.
Yes.
This takes us back perhaps to the objective-subjective question,
Well, the individual
which I will return.
the individual, unless they're acutely aware of tax consequences, may not be asking the question, are these exceptional consequences, circumstances? They're simply thinking, do I really have to be there? I can't let this happen, whether it's the death of my pet or my parents, without being there.
A cup final. One may well wish to attend.
Yes.
And feel a tremendous urge to attend your team's watch your team playing. But whether this is exceptional circumstances beyond the individual's control which prevent him from leaving the UK, which would be a question for an objective question for the tribunal, and they would not ask themselves, did the taxpayer think the circumstances were exceptional and prevented him? But were they exceptional and did they prevent him?
Okay.
I'm not sure I've quite understood what objective means. It's a very slippery
Well, my lord, that is a very good question. One, because it is a concept which is always used and requires considerable unpacking. I do address this actually in ground one, which I will come to very shortly, if your lordship will bear with me.
Well, can I go back to the cup final example?
Yes.
Because I think it's quite a useful example.
Yes.
Most of us are not so fanatic about following a team that we would regard it as a matter of compulsion to be at the cup final. But one might be a follower of a non-league team which had got into the FA Cup final, which one might characterise as pretty exceptional. And what would you say if the taxpayer, I mean, obviously people can pretend things, but if a taxpayer genuinely persuaded the FTT this was the most significant event in the last 20 years of their life and they really felt compelled to be there. What do you say the FTT should do with that sort of evidence?
The FTT should run through the 5 conditions set out in paragraph 2.3 of my skeleton.
Yes, but we're
It should,
talking...
and I'm answering the question.
Yes,
if
sure,
you'll bear
sorry.
with me. It'll ask whether the circumstances are exceptional, and it may conclude that they are, because here is a once in a century occasion where some loaded team has succeeded all the way to the final. Are there exceptional circumstances beyond the person's control? No. We will pass. So we will pass the control test. We will pass the exceptional circumstances test. 3, would the person be present in the UK but for the circumstances? We will pass that. The taxpayer will pass that test. I think the tribunal is likely to say a taxpayer would fail at 4. The exceptional circumstances do not prevent the person from leaving the UK. Because it is in these circumstances a tribunal would say that the taxpayer may think is prevented, but the tribunal will decide whether or not the taxpayer is prevented objectively. And the tribunal is likely to form the conclusion in these hypothetical facts that the taxpayer was not prevented. If the taxpayer said I had some mental aberration, now we're getting quite fanciful, but just for the sake of argument.
But the reason the tribunal would be likely to say that the taxpayer is not prevented is because of general societal expectations, isn't it?
Certainly.
So the answer to my earlier question is that is a relevant factor because society would expect you to, or might expect you to want to be there and to need to be there if a close relative is on their deathbed, but not to attend a football match, however exalted.
Yeah, very much so. Yes, I would agree with that.
Yeah. Okay.
So that concludes my observations on this round. And with that in mind, I'll go back briefly to ground 1 of my skeleton, which in fact some of which has been covered by the discussion this morning. But if we return to paragraph 3, the objective nature of the test. Perhaps I should say the objective nature of the tests, because there are 5 subtests in paragraph 22.4. Just reverting for a moment then to paragraph 2.3 of my skeleton, which sets them out. Exceptional circumstances beyond control, present, prevent, and intends. The 5th of them is not objective, it is subjective, it depends on the intention of the individual. The others, we would say are objective in the sense that it is for the tribunal to decide whether the circumstances are exceptional, whether they prevent, in the case of, in the example of the football, and so on.
Can I?
Please.
There seems to be I won't say a confusion, but there's a question as to whether this inhibition or moral obligation or whatever it is feeds into the test as to whether the circumstances are exceptional, or feeds into the test whether those circumstances prevented you leaving.
We say both.
You say both.
Yes.
Because the UT says whether circumstances are exceptional is just a question of looking at the objective factual situation, leaving out of account your reaction to it. And I'm not sure what's wrong with that. What's wrong with that?
The reaction of the taxpayer to the other circumstances is part of the factual matrix which constitute the circumstances of the case.
So the circumstances where you discovered that a close relative is dying is different from the circumstances where you discover a stranger is dying.
Yes.
And what makes the difference is your reaction.
Indeed. And if the relative was someone who you always hated and had no contact with, the circumstances would be different.
Thank you.
And the feeling, which of course will be felt by any decent person, the obligation to care for a close relative, in this case the twin sister, is part of the circumstances and part of the, and therefore which, the totality of which may be exceptional.
Yes, a point isn't necessarily limited to close relatives. I was thinking of what you might describe as Good Samaritan examples. You're on your way to the airport, you happen to be medically qualified, you pass someone who's seriously injured or you see a car accident, you stop because of your, no legal obligation to stop.
No.
But your
first
aid skills are in fact useful. Your role in that situation and in a sense your reaction, or at least the reaction of someone in your position and with your qualifications perhaps, I take it you would say would be part of the relevant circumstance.
Completely. And in those hypothetical circumstances where the taxpayer missed the plane because they remained behind to save a life, I would say that a tribunal is well entitled to find exceptional circumstances. Indeed, sudden or life-threatening injury is one of the statutory examples of exceptional circumstances. But they're also including the fact of the qualification, the fact that the individual felt, quite rightly felt, the need to help.
So perhaps the perhaps the phrase that you used a moment ago, which is a feeling which would be felt by any decent person in your position, is something.
It's very much what a tribunal would, the First Tier Tribunal ought to approach the question, decide whether or not these are exceptional circumstances which prevent.
Yes, but the relevant considerations include, well, that would suggest not only your relationship to the individual, they might be a stranger, but your qualifications, your personal, your circumstances in an objective sense, the sort of person you are, the qualifications you have,
yes, and
where you are at the time, in my example.
Yes. But another person may walk past and leave the the victim with the illness to die. They say, that's not my problem. There is an injustice in imposing tax on the person who stays in those circumstances. And this was the injustice which moved, or in the circumstances of this case, which moved the First Tier Tribunal, although it was not perceived so strongly by the Upper Tribunal.
Where you have very prescriptive tests, it's quite difficult sometimes in tax legislation to invoke notions of justice or injustice. The question is whether you come within the statutory words or not.
Certainly, but this relates to a very interesting debate one could have about the relationship between tax and justice. Tax is a set of rules, but one hopes Parliament, in enacting those rules, comes up with a system of rules which are just rather than unjust. Given a choice between constructions leading to a just or an unjust conclusion, one hopes the tribunal or court would be inclined to think that Parliament is to construe it so as to produce a just conclusion. So tax is not, there is a relationship between tax and justice, even though it doesn't always work out because the nature of the rules may not permit a just, may not permit it.
I think you're on ground one, aren't you? Are you still on ground one?
I've more or less finished ground one. My submission was
Very good.
that these are objective tests, and insofar as they're affected by the moral views of the taxpayer, it's for the tribunal to decide. It's all for the tribunal to decide whether these tests are met.
And what do you say is the relevance of pairing? Because obviously this isn't a reasonable excuse test. I think you're relying on an analogy in the approach.
Yes, my lord, exactly. This is not a reasonable excuse test, and we've never suggested it is. And the analogy is only this: that in applying a reasonable excuse test, one has regard to the attributes of the taxpayer, and in applying these tests, one has regard to them after in deciding objectively whether or not the conditions are met. It may be a bit of a red herring to follow up reasonable excuse, but as we say, it reflects a general approach to how the courts will approach a multifactorial test. You look at all the factors, all relevant factors, and then you decide. The tribunal decides, not the litigant or concerned, whether or not the statutory tests are met. In response to the question from Lord Justice Males, I would say that is what I mean by objective.
I still find this difficult as to how what's in the mind of the conscience of the taxpayer, which is a subjective thing, their reaction to a situation they find themselves in, feeds into what you say is an objective test.
If the taxpayer said, I have, in my view, these are exceptional circumstances which prevent me from going.
The taxpayer is unlikely to ask the question, how exceptional is this?
Well, they might if they would only if they having read the statute.
Only do it, but they might well, if somebody said, why didn't you come home yesterday as you were planning to? And they said, well, I had to stay. Why did you have to stay? Well, because I found X, whatever X is. And that's, as long as you accept that evidence as genuine, as the tribunal accepts the evidence as genuine, then something has stopped them from going home. How does that feed into what you say is an objective test as to whether they've been prevented from going home?
I would say that the circumstances may or may, somebody who stays here may or may not be prevented from going. It may be inhibited, if one can use another word, meaning hindered from going without actually being prevented.
And it's up to the tribunal to decide whether the reasons put forward by the taxpayer are not only believed, but meet some
Objective test to prevent.
objective standard of things which are serious enough to stop you going home. Is that?
That is it. There is a range or a whole scale of factors which may discourage a certain action. And at some point, some of them are weaker. I might wake up feeling tired, doesn't stop me getting up. And some of them are stronger. I wake up feeling ill, I may be unable to may find it difficult to get up. Some of them are insuperable. I wake up so ill I cannot get up. And where in this scale of inhibition something reaches a scale, the point where you say it prevented you, is it ideally suited as a question of fact for the First Tier Tribunal.
But this all goes to prevented rather than exceptional circumstances.
It does.
Because, yes.
It does. Exceptional circumstances come in because having decided the taxpayer was prevented, by circumstances, you then have to ask whether those circumstances were exceptional.
Yes, and you can do that applying an objective test because you're looking at whether they are
Sufficiently
out of the
uncommon.
norm or sufficiently uncommon, whatever
Yeah.
terminology you want to use.
Yes. So that takes us away from the law to some questions arising from the facts of this particular case, which are important in this particular case, but not of wider importance, which are my grounds 5 and 6.
Do you agree that ground 2 doesn't arise?
My learned friend agrees.
Yes. We don't need to worry about that.
Yes. In paragraph 18 of his, well, I don't know whether I need refer to it, but in paragraph 18 of his my learned friend skeleton, there's no need to turn to it, but what he says is ground 2 does not arise and is not further addressed. Turning then to ground 5, in paragraph 7 of my skeleton, the question is whether the First Tier Tribunal made contradictory findings on the exceptional circumstances issue. It is a classic Edwards and Bairstow factual attack on the finding of fact by the First Tier Tribunal.
Edwards and Bairstow is House of Lords. Has there been anything from the House of Lords or Supreme Court which alters what's there said?
I believe not. Edwards and Bairstow is the case which is always cited for the proposition that a finding of fact by the fact finder, in this case the First Tier Tribunal, in circumstances where there is an appeal only on the point of law, the finding of fact cannot be challenged, except in circumstances where the First Tier Tribunal has, or fact finder, has found a fact which it could not reasonably have found, or which would include a case where it finds contradictory facts. So I propose to read what the First Tier Tribunal found, and then read what the Upper Tribunal said about it. The findings of the First Tier Tribunal, paragraph 179 to 185 of tab. Tab 8. Thank you. Paragraph 179, if your lordships are with me. We consider that, to the extent of the appellant's visits to the UK in December 2015, February 2016, were occasioned by the need to care for the consequence of a twin sister's alcoholism and depression, this does not of itself constitute exceptional circumstances. To the extent that they're needed for the consequences of a twin sister's alcoholism and depression. Alcoholism and depression are not themselves uncommon or unusual illnesses. It is true that both conditions cause much suffering and distress, both for the individual concerned and for that individual's family. We do not, however, consider that they are exceptional circumstances. That's the first part of what is said to be contradictory. Moving on, at 180, we've also considered whether the fact that the twin sister had minor children, for whom the appellant also cared, alters a position. We consider this to be a more difficult and finely balanced question, but in our view it does change the position. It is clear that the appellant was under no legal obligation to care for her twin sister's minor children, as we've concluded earlier, we do not consider it necessary for there to be a legal obligation in order for there to be exceptional circumstances or one which prevents a taxpayer leaving the UK. Moral obligations, and we've covered this already. Moral obligations can qualify as exceptional. They did say they do, but they must, but they can. 182. And this is the second part of the finding, which is alleged to be contradictory. In our view, the combination of the need for the appellant to care for her twin sister, and particularly for her minor children, at a time of crisis, and I stress the word crisis, caused by the twin sister's alcoholism, does constitute exceptional circumstances for the purposes of paragraph 22.4. I can skip the next paragraph, we'll just read 184 and 185. The appellant's evidence, which we accept, was that when she arrived at her twin sister's house in December 2015 and February 2016, and that at both occasions, she found a dysfunctional household, I stress the word dysfunctional, in which her twin sister was drunk and incapable of caring, and I underline that too, incapable of caring for herself or her children. When the taxpayer arrived at her twin sister's house, she found both her sister and her children were unkempt and in need of care. The house was filthy, I stress that. There was nobody else, and I stress that, who could provide the care needed. And then skipping perhaps to the next paragraph, we think it more probable than not that when coming to the UK in December 15 and February 16, the appellant did not appreciate the seriousness of the situation, i.e. the extent to which the sister was no longer able to cope with running her household and looking after her children until she, I find, actually arrived. Although she was aware her twin sister was an alcoholic, she did not appreciate the extent towards her twin sister was incapable of coping with the running of their household and care of her minor children. The immediate need, and I stress that, to seek the establishment of a stable household in which minor children could be cared for does seem to us to be an exceptional circumstance outside the appellant's control. So, the tribunal is contrasting in 179. Alcohol and depression are not in themselves uncommon or unusual illnesses which cause much suffering and distress, on one hand, and what they find to be exceptional on the other hand, at 182 onwards, which was a crisis, which was a dysfunctional household, which was a filthy house, and the mother incapable of caring. And we say there is no contradiction between those separate findings of fact, because this was a case which went beyond what you might loosely call the ordinary effects of alcoholism and depression, which are not exceptional. Then we turn to see what the Upper Tribunal said, paragraph 102 to 106. Upper Tribunal being tab 4. Paragraph 102, if your lordships are with me. My learned friend submitted, if alcoholism does not constitute an exceptional circumstance, notwithstanding the consequences it has for individual and family members being in the UK to deal with those same consequences, cannot amount to exceptional circumstances. The FTT's conclusion was internally inconsistent. 104, Mr. Kessler, I argued that there was no inconsistency, as I do again this morning, because the position of the taxpayer in the family went beyond mere alcoholism. I said then, I will say it again, you don't often go into a house and find squalor like this, referring to the condition of the sister's house as described by the taxpayer. However, as my learned friend submitted, this was what the Upper Tribunal decided, the FTT made no finding that the degree of suffering and distress caused by the alcoholism and depression was more than that which commonly arises in families which are affected by those conditions. Well, they may not have used the words more than commonly arises, but they describe them vividly in the passage I have read. The dysfunctional family, the crisis, the filthy house. And held, we would say rightly, but certainly they're entitled to hold, that these were exceptional circumstances. That takes me to the question of expert evidence. Going back for a moment to a sentence in the Upper Tribunal decision at 105, the next sentence. They observed there was no evidence to that effect, that is to show the circumstances were exceptional, such as from an expert familiar with the impact that a combination of alcoholism and depression can have on such families. We did not call an expert to inform the tribunal of what is or isn't commonly to be expected in relation to alcoholism. We say there was no need to call an expert. This is a matter well within the ability of a tribunal to decide. It does not need an expert to say that a crisis is exceptional, that a filthy home, uncared for children covered by nits on the second visit constitute exceptional circumstances. I don't want to overlabour the point, but the other findings of fact which in the FTT which I should briefly refer to before I can move on to my last ground, and that's the First Tier Tribunal passage at 66 and 71. First Tier Tribunal being at 8, 66 and 71. This was the evidence that the tribunal record. The appellant said that in the few days that she was with her twin sister, she was shocked at her sister's obvious decline. Indeed, the reader might be. Her twin sister's house, she said, was, she commented, neglected and in a disgusting state, to the extent it needed professional cleaners to sanitize, unpleasant word, the interior, and make it habitable.
This is on the February visit.
This was on the second visit, yes.
One of the points by the UT is that the FTT didn't really, they looked at it globally, they didn't really look at each day.
Yes,
is that a point you're
I'll come to that in ground 6.
Yes, I thought so. Thank you.
It will be my last point. That's paragraph 66.
So this paragraph, the last sentence, the reason that the taxpayer had to stay was due to the suicide risk.
Yes, and on that point,
Which
on
they
balance
didn't
of
accept.
probabilities, the evidence was not accepted.
Yes. I mean, they don't find here, do they, that it took her a few days to reach the point where she was satisfied the house was clean and the children were cared for, which is the only exceptional circumstance which is now in play.
No, but they do find that the house was in this well, at least they state the evidence, and I infer that they found that they accepted that the house was in a shocking state when she arrived. Exceptionality. I'll come very shortly to the day-by-day test issue. The last paragraph I will read on this aspect of whether or not the findings to justify their conclusion is paragraph 71. And I will just read the first sentence of paragraph 71. The appellant's recollection of both visits, this is relevant to each of them then, December 15 and February 16, was that on arrival she found a completely dysfunctional family household. Her twin sister was drunk and incapable of caring for herself or her children. It's one thing to say that alcoholism brings distress to the individual and their families, and another to reach the stage of affairs described in that sentence in paragraph 71. That takes me to the last of my grounds, ground 6 in paragraph 8 of my skeleton. It is common ground, it always has been common ground, that the conditions need to be satisfied each day, at the end of the relevant day, and the First Tier Tribunal found that this was the case, and we should briefly look at the passage, perhaps, paragraph 185. We accept that the appellant would not have been in the UK at the end of each day relevant to this appeal, but for the fact she needed to care for both her twin sister and her minor children. We further accept that this need prevented her from leaving the UK until such time as she had stabilised the situation, and that she intended to leave the UK as soon as possible, once those circumstances permitted. Turning then to see how the Upper Tribunal dealt with this point, paragraph 92. Paragraph 91. My learned friend submitted that there was no evidence before the FTT to support in conclusion that the taxpayer was, quote, prevented from leaving the UK, unquote, on 18th or 19th December because she needed to care for her twin sister and her mother. We agree. The only evidence before the FTT about the reason why the taxpayer considered she was unable to leave was that it took her 3 days to reach a point where she was satisfied her twin sister was no longer at risk of taking her life. However, that evidence was rejected by the FTT. The FTT's finding about the first visit was not based on any evidence, and so constitutes an error of law. I set out some of the evidence in paragraph 8.3 of my skeleton. Rather than running through every paragraph, I will just summarize it here. 8.3.1, for both visits, the taxpayer and her twin sister were particularly close. It's not possible to rely on friends the same way as family. There was an immediate need to establish a stable household in which the minor children could be cared for. And the evidence of the taxpayers concerning the state of affairs she found, as opposed to the suicidal point on which, on balance of probability, she was not believed, was convincing. On the first visit, there was evidence of a dramatic plunge into drug and alcohol addiction, and, quote, many practical steps, unquote, taken to stabilise the situation. For the second visit, the taxpayer was shocked. The house was, as we've read, neglected and disgusting. The children were crawling with nits. The twin sister was still drinking excessively, and everything in that week revolved around looking for her sister and her children. Ample evidence, one might say, for the FTT to reach the conclusion that it did. At 8.4, I quote a general comment from the recent case called Anna Cook. Quote, the bar to establishing an error of law based on challenges to findings of fact is deliberately set high. And this is particularly so where the FTT is called on to make a multifactorial assessment, such as exceptional circumstances, and the rest of the factors. As stated by Lord Justice Evans, for a question of law to arise in circumstances, the appellant must first identify the finding to be challenged, secondly show it is significant, well, there's no doubt about that, thirdly identify the evidence, and fourthly show that the finding on the basis of that evidence is one the tribunal was not entitled to make. What is not permitted is a roving selection of evidence coupled with a general assertion that the tribunal's conclusion was against the weight of the evidence and therefore wrong. in relation to the roving selections evidence, I set out some comments on the Upper Tribunal's comments in the boxes at 8.5 of my skeleton. Suggesting the hostile approach of the Upper Tribunal to these findings of facts. Firstly, the Upper Tribunal noted the absence of other witnesses. The only witnesses were the taxpayer and her husband. How many witnesses does one have to call to describe a state of affairs like this? The tribunal may deprecate a decision to extend the length of hearings and make tax litigation even more expensive than it already is by calling witness after witness in case they're criticised for not pitching up. But the FTT found we draw no adverse inferences from the failure to call any witnesses. Number two, records. The taxpayer did not make any record of what she had done on each day of the visits, even in outline, or why she had concluded at the end of each day that the sister's condition was such that she was prevented from the UK. She did accept that an itemised timeline for each day, as suggested by HMRC, was not necessary. But HMRC, my learned friend, argued, and perhaps may argue again, that if you don't keep a diary, you only have yourself to blame if you don't have the evidence to support the finding a fact for which you want to say. It is totally unrealistic to expect anyone other than a tax practitioner in the circumstances of this case to keep a diary of exactly what she did each day. It is totally unrealistic to expect her to remember 6 years later, before the tribunal, what she did each day 6 years previously. Speaking for myself, I find it difficult to remember what I did 2 weeks ago, never mind 6 years. I put down here in the second box, if an individual did keep a diary for tax purposes, which might happen if they were advised contemporaneously by a tax advisor to do it, or if they were a tax practitioner, I might, in the same circumstances, say to myself, I need to keep a diary to satisfy matters of revenue and customs. Then it would be denigrated as a self-serving document, and it would be a self-serving document. Likewise, in the next box, the Upper Tribunal said the taxpayers' evidence was defensive and vague. Didn't refer, as far as vague is concerned anyway, as to the delay in giving the evidence, or the fact that the evidence was found to be convincing. Lastly, the Upper Tribunal said we consider the FTT ought to explain why it accepted taxpayers' evidence after rejecting the evidence on the main case, that is the case of suicide. Completely rejecting, meaning they found on the balance of probabilities they weren't convinced. But we say there's nothing unusual about accepting part of a taxpayer's evidence and rejecting another part. And the manner in which they gave their decision is perfectly satisfactory. The tribunal did deal with those days as a group, which passed in a blur, or were remembered as a blur, and was entitled to find that the exceptional circumstances were the exceptional circumstances throughout, and so for the rest of the conditions. If one requires more than that, then this will be an extremely difficult provision to satisfy. That concludes all the points I have in my skeleton. The only other point I will mention at this point, we leave the rest if I have to come back during my reply, concerns a point of my learned friend on what one might loosely call the pleadings, where he says There are certain points which we should have addressed, which we didn't, which we failed to challenge. And having failed to challenge, we can't challenge them now. We must lose on that ground, even if we win on all the arguments I've raised this morning. And that is Lotharian Skeleton, tab 13. Oh, no, sorry, Lotharian Skeleton. Which tab is the skeleton?
Tab 13.
Tab 13. 16.8. And this is the very last point I will make before I sit down. My learned friend says at 16.8 in the last sentence of the full paragraph, there was no separate challenge to the Upper Tribunal's analysis, which led it to conclude that there were no exceptional circumstances in this case. In particular, there was no challenge to the following conclusions. A, that the appellant's circumstances were not similar to the statutory examples of exceptional circumstances. That is, they were not similar to national or local emergencies, certainly, sudden or life-threatening illness or injury. Well, there was illness or injury if alcoholism is an illness, but what we say is those are simply examples, helpful as far as they go, they illustrate what may be exceptional, but there is no reason why you cannot have other exceptional circumstances which are not among those mentioned. Paragraph 22.5 says examples of circumstances that may be exceptional are, and sets out the two lists. B, the complaint is there was no finding by the First Tier Tribunal that the circumstances, as the appellant found, were any different from suffering and distress commonly caused to the families by those suffering alcoholism. Well, they described in graphic detail the circumstances. And if they do not say in a sentence, well, we regard these as different from mere alcoholism, it was clearly implied. As far as our grounds are concerned, I've covered this in my comments on in my ground 6. C, the finding that the appellants needed care for her sister and children did not make the circumstances exceptional. It's the whole tenor of my submissions, we say, that is precisely what what happened, and at 16.19. The Upper Tribunal, having found the combination constitute exceptional circumstances, it failed to address the other requirements of 22.4 by reference specifically to that combination. That conclusion is not challenged on appeal. But what we challenge on appeal in our ground 6 is that the 6 tests were not met on a day-by-day basis. So I invite your lordships to dismiss the pleading argument and concentrate on the other arguments of this case. Now, unless there are any other points I can assist the court, I can sit down.
Very good. Thank you very much, Mr. Kessler.
Thank you.
Mr. Stone.
My lords, my lady. I intend, if I may, to take the argument slightly slower than my learned friend did, and start with a sort of proper introduction of the issues and how they arise on this appeal and what the Upper Tribunal actually decided. If any of my submissions you wish me to speed up, please do say so. Starting then with that introduction about the issues, there are 6 grounds of appeal before you. It is common ground that ground 2 does not arise, and I will explain why that is in due course. All of the 6 grounds concern whether the Upper Tribunal was entitled to interfere with the decision of the FTT and find that the FTT had made an error of law. As you all know, there were 4 grounds of appeal below that HMRC brought to the Upper Tribunal. And if I can just show you those, please. They are in the court bundle, the hearing bundle. It's in the Upper Tribunal decision, and it's page 43 of the bundle. And it's paragraph 48 of the Upper Tribunal's decision to which I refer. So the first is that the FTT had erred in paragraph 150 in deciding that the requirement that the circumstances prevented the taxpayer from leaving the UK could be met by a moral or conscientious inhibition on the taxpayer leaving the UK, and in applying that test to the facts of the taxpayer's case. So there were two limbs. There was the sort of the theoretical and the application. And then the second ground of appeal, in failing to apply each of the elements of the statutory test to each individual day, the FTT erred. Thirdly, in finding that there were exceptional circumstances in the taxpayer's case. And fourthly, having found that there were exceptional circumstances, failing to consider whether those circumstances satisfied the remaining elements of the statutory test. Each of those grounds of appeal was upheld by the Upper Tribunal, and each of them, I would submit, entitled the Upper Tribunal to set aside the decision of the FTT and remake that decision. The Upper Tribunal remade the decision as paragraphs 126 to 128, and you find that at page 55. The reasoning of the Upper Tribunal at this stage is necessarily brief, but of course it encompasses all the discussion that we've already had in the decision about what exceptional circumstances are, what it means to prevent you, the need for exceptional circumstances to prevent you leaving the UK. There is no challenge to this remade decision. So therefore, in this appeal, unless my learned friend can show that the Upper Tribunal was not entitled to interfere with the FTT's decision, i.e. unless he can show that there was no error of law, then the appeal must fail in this court.
Sorry, is that right? If we concluded that the UT made an error of law in its analysis, then we're certainly entitled to that decision.
But the analysis of the UT that my learned friend challenges is not this analysis in these paragraphs here. It is the analysis at the earlier stage in which the UT has found that there was an error of law by the FTT. So what my learned friend is saying is the Upper Tribunal is not entitled to find there was an error of law, and therefore you don't get into remaking.
But if we, I'll just repeat this, if we decide that in its reasoning the UT made one or more errors of law, do you say we should sort of leave that to one side and simply decide whether, simply look at the FTT decision to decide, however it expressed it, that the UT was not entitled, whether or not the UT is entitled to find an error in the FTT decision?
My submission, my lady, is that there were a number of errors in the FTT decision that the Upper Tribunal correctly identified, which therefore enabled it to set aside the decision and remake the decision. And the position of my learned friend is there were no errors in the FTT's decision, therefore the Upper Tribunal wasn't entitled to interfere.
Isn't this rather academic? Because the remaking is expressly based on our analysis of the legal provisions, which amounts to saying that the FTT got it wrong and the position is as the Upper Tribunal set out. So it all depends on showing that there are errors in the FTT. If there are, and if there aren't, there aren't.
Indeed. Yeah. It may be as simple as that, my lord. Sorry, it is that if there are errors, then because it could be said, it has been said in other cases, that yes, there were errors or if there were errors by the FTT, then the Upper Tribunal still erred in how it remade the decision. And it is a short point I make, which is that remaking is not itself challenged, but of course, its ability to remake turns upon there being errors in the FTT decision.
I'm not sure it is quite as simple as that, as my lady says. As you yourself said, the remaking is a very short paragraph, in paragraph 128, and it refers back to their previous analysis. if we thought that their previous analysis was flawed in some respect, then that would necessarily affect the way in which they remade it.
My lord, yes.
It's not quite as simple as saying, well, unless the appellant succeeds in challenging all of its grounds, then there's no challenge to the UT's way in which the UT remade the decision. I mean, if one looks at 128, there's two conclusions. One is the circumstances weren't exceptional, and the other is the taxpayer wasn't prevented from leaving by exceptional circumstances. And we might, in theory, come to the conclusion that the UT's criticism of the FTT in relation to exceptional circumstances was unjustified, and that the FTT got it entirely right on exceptional circumstances, but that the UT was right on prevention. We'd still have to re-look at the question, wouldn't we, how that impacted on 128.
My lord, yes. In those circumstances, I accept that you follow through the logic into 128. I said I would explain why ground 2 doesn't arise, and it is because, as you see, whilst we're here on 128, the Upper Tribunal concluded that the taxpayer was not prevented from leaving by exceptional circumstances. The ground 2 was premised on the Upper Tribunal having found the taxpayer was not prevented from leaving. So we say, well, that it is correct. It did not make that finding. It found specifically it was not prevented from leaving by exceptional circumstances. So my learned friend opened on exceptional circumstances and said the prevent did not now arise, but he did address you on ground 1 of his appeal, and I intend to do so as well, because there is an overlap between the analysis of exceptional circumstances and the analysis of preventing, which I think my Lord Justice Nugee brought out in the course of submissions.
Can I just be sure, you accept therefore that the taxpayer was prevented from leaving?
My Lord, it was said by my learned friend that that's common ground. We don't accept that that is the case. It is not an issue that arises on this appeal because of how the Upper Tribunal dealt with it. So its focus was not on prevention full stop. Its focus was on did the exceptional circumstances prevent. Whilst we still have this page of the Upper Tribunal's decision in front of us, can I note please paragraph 125, in which the Upper Tribunal set out some brief but practical guidance for FTTs in deciding appeals under this paragraph. I would invite the Court of Appeal to endorse that guidance, given it provides a helpful structure, not only for tribunals, but also some structure for taxpayers and HMRC when addressing these matters. And maybe give you a moment to review it. Before turning to the grounds, sorry, my Lord.
Yeah, carry on.
Before turning to the grounds of appeal, can I just pick up my Lady Justice Falk's question about the reference to IR20 in the decision? The reason that the Upper Tribunal considered it was to draw a comparison between the test as was set out in the guidance and the test now in the statute. The particular point being that the test set out in the guidance in IR20 did not refer to the concept of preventing from leaving the UK. It was HMRC's submission in the Upper Tribunal that the test that the FTT applied did not have proper regard to the additional requirement of preventing leaving from the UK. And so the submission was that although the FTT's test that it applied may make grammatical sense if you remove the requirement to prevent someone from leaving the UK, that is not the test which Parliament has written into this legislation, and therefore in construing and interpreting the legislation, you must have proper regard to what Parliament intended by that requirement.
I mean, we did see paragraph 60, to the extent you're focusing on the word prevent, did up with guidance to include the word prevent.
So the HMRC, that was the point I was making earlier, the HMRC 6 did, but you'll see paragraph 61 what the tribunal, the Upper Tribunal took from it. Before the enactment of the SRT, there was...
So is HMRC 6 the new?
That was, so IR20 was replaced by HMRC 6 in 2009, and then 2009 to 2013-14 was HMRC 6.
Right, so it was still before the statutory residence
Yes.
test. Okay, thank you.
And you can see, my lady, if you're still there, I would invite you to just to glance at paragraphs 57 and 58. This was the context in which the Upper Tribunal went to the previous guidance, because it was to deal to effectively support from my submission that you have to have proper regard to what is meant by the phrase prevent from leaving the UK. And you'll see to prevent is in HMRC 6, but it's only as one part of the example. So it wasn't a separate criteria, if that makes sense. Therefore, when one is, and this case was about construction of this piece of legislation, and when one is construing it, identifying how and why Parliament has used the words it has, and how it may or may not have strengthened or tightened the requirements gives you some insight into the proper construction.
So you would accept that the earlier guidance may be relevant in giving context?
It is only for that purpose to give context.
No, obviously, but you accept it may be relevant for giving context.
When one is looking at the purpose of Parliament in enacting what they did, the previous guidance and obviously the consultation document that was referred to by the Upper Tribunal may be of some use.
We don't have that consultation.
My Lord, you don't. You have the quotation from the relevant consultation document. I'll be coming to it in a moment, my Lord, but the short point is that it sets out the need for a transparent and objective test, and one that is easy to apply. So clearly before the implementation of the SRT, residence was determined on common law, a multifactorial test. The purpose of Parliament in enacting is set out partly in that consultation document, and that again does feed into the process of interpretation for the court, because it directly goes to the taxpayer's point about moral inhibitions and whether it would have been Parliament's intention that the strength of a moral reaction to circumstances can itself be an exceptional circumstance. And we would say that that is contrary to the purpose of Parliament in enacting a statutory test. Can I turn, my Lord, to the grounds of appeal and start with exceptional circumstances, as my learned friend did? And just, if I could invite you to go in the hearing bundle, please, my Lord, to page 16. These are the grounds of appeal, and it may be helpful just to remind ourselves. The three which are relevant to exceptional circumstances are numbers 3 through to 5. 3 is that the Upper Tribunal erred in holding that whether circumstances were exceptional was a question of law. 4, the Upper Tribunal erred in holding that moral obligations cannot be or cannot be part of exceptional circumstances. And 5, the Upper Tribunal erred in holding that the FTT made contradictory findings on the exceptional circumstances issues. And I intend to take those 3 in turn. could I, before doing so, just remind the tribunal of the bare bones of the factual context, because it is important to the decision that the FTT and the Upper Tribunal reached. And I will take this relatively briefly. As the court will be aware, the taxpayer became non-resident in Ireland on the 4th of April of the year before the one that we are concerned with. She did not separate from her husband, but her husband continued to live in the family home outside of Manchester. Because of the number of ties that the taxpayer had to the UK, there were a maximum of 45 days, or as it is, nights, that she could spend in the UK and still be non-resident. By November 2015, which was 7 months the way through the tax year, she had already used up 44 of those days. So there were, as she knew at the time, she could only have one more day, and if she took 2 more days in the UK, she would trip over into being resident. It is relevant that, and it was, my submission was below that it was relevant.
Is there a finding of fact that she was aware of the 45-day limit?
Yes, my lord, I'll find the paragraph reference for you, but the findings were that she was professionally advised by KPMG,
Yes.
that when she moved to Ireland, that she knew about the day counting rules, and she knew that she had to keep a record of where she was each day. And specifically, she knew when she was in the UK on the 20th of December, so that was during the first visit, if I can use that word, she knew that she would be relying on the exceptional circumstances exemption.
You say that she knew she had to keep a record of where she was. Did she keep such a record? And there were aviation records of her jet, but did she keep a diary saying this is where I spent the night? Because I thought the evidence was that it wasn't clear whether she spent the night with her sister or with her husband.
Well, my lord, the country in which she was clear. So it was clear which days.
Was that because she kept a specific record for this purpose, or was it something deduced from other evidence?
I will, over the short adjournment, I'll check the point. But my recollection is that there was a running total of the days in each country, rather than having printouts or photocopies of a specific diary page that said, I'm here. And certainly it is the case, my lord, that although her evidence was that some nights when I was in the UK I stayed with my husband and some nights I stayed with my sister, the finding of the FTT was that she was not able to recall which and had no record of which.
Thank you.
So the reason that that bit of background is relevant is, of course, it goes to my learned friend's criticism that HMRC's case was unrealistic to suggest that the taxpayer should have kept a note of what she was doing. This was somebody who was professionally advised who did know that she would have to satisfy the revenue as to those tests. And of course, we take into account these were not easy circumstances for the taxpayer, but it was never suggested she had to at the time sit down and note these. But it was said that if you want to prove on the balance of probabilities that you are prevented from leaving, then some record after the event is kept to establish what it was you were doing, and in particular, why it was that you were able to leave on day 5, but not able to leave on day 4. Now, this goes ahead to the ground, the last ground of appeal of my learned friend, but that is the analysis that the Upper Tribunal says the FTT should have engaged in if it were to find that all of the statutory conditions were satisfied on each of the days. But there was no evidence of what the taxpayer was doing on particular days.
That's simply a matter of evidence, isn't it, of how easy it is for the taxpayer to prove that she qualifies under the exceptional circumstances paragraph. I mean, if she can give oral evidence which is believed that she hasn't got any record at all, she's proved it sufficiently for FTT purposes.
Certainly, my lord. It is a matter of evidence, but the Edwards and Bairstow challenge was on the basis that there was no evidence, oral or written, contemporaneous or otherwise, that established why the statutory conditions were satisfied on each of the days.
Yes. All right.
So clearly it is a matter for the FTT, subject to the FTT making findings on which they were. My Lord Justice Nugee asked the question about a finding of factors to the taxpayer's awareness of the test. Could I invite you to go please to page 88 of the bundle?
Thank you.
And invite the court to read paragraph 104, which is in the FTT's decision.
That suggests that she did keep a day count in a diary. So this is just a diary saying Dublin, England.
Manchester. I'm afraid I can't assist at this stage with the format in which it was presented. But it is I'm certain it's common ground that there was nothing that broke down a day into activities or suggested a place of sleeping. The next part of what I say is the relevant background is the condition of the sister and its longevity. In that regard, can I please invite the court to go to page 53 of the hearing bundle and read to itself paragraph 113. This is in the Upper Tribunal's decision. And this picks up 2 points that were arose from discussions with my learned friend. The first is Lord Justice Nugee's question about foreseeability. The FTT had found that foreseeability may be relevant but is not determinative, and it's correct that that was not appealed on the basis that by itself it will not be determinative, but because the FTT had said it is a relevant factor, that is a position that the revenue agreed with. The other point that is picked up is my Lord Justice Mayall's point about somebody, when they become non-resident at the start of the tax year, knowing that there is a possibility or a probability that they may have to come back because they have a relative in the UK who may die at a certain time or may be ill at a certain time. HMRC are not casting moral judgments as to how people react to those situations, but the reality is that there is a day count, a number of days there to be used. And it is the revenue's position that if at the start of the year somebody reasonably anticipates a need to be in the UK, then it is reasonable to expect them to work out the number of days they spend in the UK, having regard to that need, such that it is, and that if somebody says, well, I've used up by 6 months, say 7 months through the tax year, I've used up my day count, I now want to rely on exceptional circumstances. Well, if the test is not satisfied, it is not that the test is itself unduly harsh, but rather the taxpayer who knows they may well have to support somebody living in the UK because of their ties with the UK can be expected to arrange their affairs accordingly.
Are you suggesting that that should affect the interpretation of the rules? Because we discussed earlier, that even if you've used your, in this case, 45 days, you can have 60 days worth of exceptional circumstances. Surely, just a question of working out, in accordance with these grounds of appeal, whether the FTT was entitled to conclude as it did that there were.
My lady, it does not affect the interpretation of the statutory language. The reason I raise it is it addresses a point that the FTT raised in their judgment, where I paraphrase, I don't have it before me, but effectively they say it cannot be in Parliament's intention that somebody would not be able to come back to deal with a sick relative.
You answered that with, well, if they could have been in circumstances where they should have been able to anticipate it, they should have anticipated it. But in many cases, it may not be anticipated.
And that is certainly true, my lady.
But there's are you suggesting there should be a difference in approach between them?
My lady, no. I'm fully advocating that the legislation is interpreted in accordance with the statutory words. My submission will be that the FTT erred in not giving proper effect to all of the statutory words. And one of the reasons that it did that is because it interpreted the legislation to achieve a certain presumed intention of Parliament, which was that somebody should be enabled to come back to the UK if they wish to be with a sick relative. Effectively, is my submission that the FTT watered down the test because it considered the test too harsh.
I'm still not, I'm sorry, quite clear what role foreseeability plays in this submission. Imagine two different taxpayers. One of them has a close relative in the UK and has no reason to think at the beginning of the year that there will be any reason for her to attend, but an unexpected sudden illness strikes her sister and she feels compelled to go and be in hospital with her and look after her children. The other taxpayer also has a sister but knows at the beginning of the year that there's a real risk that circumstances like this might occur. And when they do occur, it does exactly the same. Are you saying that the application of statute differs in those two circumstances?
It will be a matter, my lord, of fact for the particular tribunal, but the ways in which it may differ is that a tribunal may find that the person whose sister is unwell and is unwell regularly throughout the year, that might not be an exceptional circumstance in the circumstances of that taxpayer's life and her sister's life. The other way in which it may be relevant, and that was not found on the facts of this case, but it may be that something is within the control of the taxpayer if something is so foreseeable that effectively they could do something about it, such that they were not required to be in the UK. I don't want to take it too far down that route, but they are the ways in which, on certain facts, foreseeability may impact.
But it's the circumstances that have to be beyond your control, isn't it?
They do, but it could be the case that you can, and it just
It doesn't seem to me, Mr. Stone, that simply because you can see that something might happen, that makes the thing that is going to happen in your control. And it's, as I understand it, the control bit of the test, not about whether you could have arranged your affairs differently so as not to have used up your days. It's about whether the circumstances are anything you could do anything about.
That is quite right. That's quite right, my lord. And certainly, I raise it as a hypothetical, but certainly the foreseeability is going to be much more obviously relevant to exceptionality of the circumstances.
Okay, thank you.
final point on the factual context before I turn to the grounds of appeal themselves is the one that the court will, I'm sure, be aware of, which is that the principal factual issue determined by the FTT was why the taxpayer was in the UK during the 6 nights that she claimed to fall within the exemption. The taxpayer's case was that it was because her sister was at risk of committing suicide. But the FTT did not find that evidence credible. And the Upper Tribunal sets out or summarises the reasons why, but they include the evidence being contrary to the objective contemporaneous evidence of shopping and restaurant receipts, the lack of involvement of any professional or medical assistance at the time, the fact that the taxpayer did not change her itinerary to fly home from Rome at the start of the second visit, notwithstanding her access to a private jet. And as the court will be aware, the FTT found for the taxpayer on an alternative basis the need to care for her sister and children because of the sister's alcoholism and depression were exceptional circumstances. Can I turn, my lord, please, to ground 3, which is whether a question of exceptional circumstances is one of law or of fact, and this is obviously directly relevant to the Upper Tribunal's ability to interfere. I say that the Upper Tribunal was correct in the approach it adopted, but highlight at the outset that this question of law or fact is somewhat academic on the facts of this appeal, because the Upper Tribunal found in any event that the FTT's finding that there were exceptional circumstances was internally inconsistent and thus perverse. So even if the jurisdiction of the Upper Tribunal could only be engaged to interfere with the FTT's decision if it found perversity, well, it did find perversity in this case. But in any event, I do say that the correct interpretation of this piece of legislation was an issue of law, not one of fact. There are a number of authorities in the bundle that my learned friend didn't take you to. I'm sure the court is familiar with them, or most of them, but could I please show you some brief passages in 3 of the decisions which are...
Yes, just before you do, you say the interpretation of legislation is a question of law. What precisely is being interpreted here? The meaning of exceptional, or what?
The meaning of the phrase, my lord, and that is an important matter, that this is not a piece of legislation that turns on one word, such as exceptional. It is a composite phrase which encompasses exceptional circumstances beyond your control which prevent you from leaving the UK. And then obviously you have to intend to leave as soon as you can. So Parliament's intention in using those words in that phrase and the circumstances or what it intended to fall within that phrase, that, my lord, I say, is an issue of law, or at the very least mixed law and fact. And as we'll see from the authorities, is certainly a type of question of statutory construction which the highest authorities suggest that would be up to the Upper Tribunal to consider whether the FTT had got the interpretation correct or not.
That suggestion that what one has to do is interpret the composite phrase slightly cuts across what Mr. Kessler submitted was common ground, that there are 5 separate conditions which have to be met, which should be looked at individually. And do you say he's wrong in describing that as common ground?
My lord, it was common ground that you can break down the words of the legislation into those composite parts, and that when a tribunal wants to test the legislation, it may be useful to go through them in the way that the Upper Tribunal described. But one has to, of course, read the words in the context of the other words around them.
You see, you said to my lord that what you need to interpret is a composite phrase, not just a single word such as exceptional. But once you break down the conditions for the application of this exemption into 5 separate conditions, one of which is were the circumstances exceptional, one does need to ask the question, doesn't one? What did Parliament mean by exceptional in this particular
context? But my lord, maybe
so
could I please rephrase it slightly then? And the better way of putting the point may be that on this appeal did not turn on the meaning of one particular word, such as exceptional. So if we look at the first ground of appeal that was determined by the Upper Tribunal, it was that the FTT had erred in finding that moral inhibitions can themselves be an exceptional circumstance. That is clearly, in my submission, an error, an issue of law as to whether the FTT was right or wrong to say that moral inhibitions can count as exceptional circumstances. It doesn't turn on the precise meaning of what is exceptional, and it does not turn on a difference of opinion between the FTT and the Upper Tribunal as to the meaning of the word exceptional.
I see. Thank you.
So whether something such as a moral inhibition is capable of being or contributing to an exceptional circumstance would, on your case, be a question of law.
Yes.
But whether the particular circumstances in the twin sisters' home and with her children are more than mere alcoholism of the twin sister would be a question of fact, wouldn't it?
Whether, on the basis of the primary facts found by the FTT, whether those circumstances were exceptional would be a question of fact for the FTT, albeit, my lord, I say this again, the context of the legislation is important. So one has the statutory examples. And the relevance of the statutory examples, how one takes them into account, may well be an issue of law. But when one breaks it down to the final question of were these circumstances exceptional, then in that context, exceptional is an ordinary English word, and that is a matter left for the tribunal, subject to some kind of perversity challenge.
So if I've understood you correctly, you say that exceptional needs, as a matter of legal interpretation, to be given a meaning that effectively excludes moral inhibitions. At least you say that the UT was right in that respect. That's your sort of starting point. You get past there and then you decide whether the facts, with that caveat, as it were, allow to exceptional circumstances.
So, my lady, if I've understood you correctly, my lady, the first point, yes, the question of whether moral inhibitions can be exceptional circumstances is an issue of law. We say the FTT found that they could, and we say the Upper Tribunal found that the FTT had erred, and it was entitled to do so because it was deciding.
Well, you say entitled, but that's not the right word, because you say this is a question of law. So equally, it's a question of law for us, if that's right, to decide whether, as a matter of legal interpretation, the reference to exceptional circumstances must exclude all, I think you'd say, moral inhibitions.
Well, my lady, as an issue of law, and certainly it is a matter before this court as well. The reason I use the word entitled is that my learned friend's case is the Upper Tribunal. This is an issue of fact, and therefore it was not, the Upper Tribunal was not entitled to review it unless it found.
I suspect it's just a distinction here without a difference, because by saying it's a question of fact, that is against your argument that there is a legal requirement to exclude moral inhibitions.
Manny said it's an unimportant difference, and certainly, my lady, the authorities that I was intending to show you make the point that spending too much time worrying about what is an issue of law and an issue of fact is not productive for this court. So apologies if I've led us down this track.
Indeed, but I mean, what's probably more helpful for me at least is to understand what you say is the basis for this exclusion of moral conditions.
My lady, that is effectively ground 4 of the grounds of appeal, which I'll come to in a moment. I say the only reason I raise this point is to deal with the argument that's put against me by the appellant that this is all an issue of law that should be left for the FTT. If I can maybe briefly show you, or as briefly as I can, show you some passages that address that question, and they're in the authorities bundle. And again, you will forgive me if these are familiar. And the first is Moina, which is in the authorities bundle at page 241, or start at 241. The case was in the House of Lords, and the issue concerned access to disability living allowance. The facts and the law itself do not concern us at all. All I would ask you to note, please, is the statutory test, which was set out at the bottom of page 241. And if I could then ask you to go forward to page 246. Lord Hoffman, by paragraph 20, had found that the tribunal had been entitled to find that the test was met, and it was therefore not necessary for it to consider an alternative submission. So what follows is strictly obiter, but I would say highly persuasive. And so it's picked up at paragraph 21. And if I can invite you to read paragraph 21, please. And then in paragraph 22, you have the quotation from Cousins and Brutus that my learned friend relies upon in his ground 3. And what Lord Hoffman said in paragraph 23 is, I think these observations have been given a much wider meaning than the author intended. And then he makes some comment. The last 3 lines of paragraph 23, on the other hand, Lord Reed insisted that whether the statute used simple words or difficult ones, its construction was a question of law. So the point is the construction of the statute is a question of law. And then halfway down paragraph 24, towards the left-hand side, the meaning of an English word is not a question of law because it does not in itself have any legal significance. It is the meaning to be ascribed to the intention of the notional legislature in using that word, which is a statement of law. And so that is authority for the proposition that when you are considering the meaning of the words used in the legislation, that is an error of law. And then at paragraph 28, 4 lines down, he remarks, I therefore think that properly understood, Lord Reed's remarks in Cousins and Brutus do not lay down some heterodox principle which provides a shortcut to dismissing an appeal, the last resort of counsel appearing on behalf of the respondents, are in accordance with established principles and common sense. I do say that to the extent that ground 3 was an attempt to short circuit the appeal and suggest that this was all a question of fact and not law, it was incorrect to do so. The next,
I have some difficulty understanding what Lord Hoffman is arguing against there. What Lord Reed says in Cousins and Brutus is, it says 3 things, I think. It says the meaning of an ordinary English word is a matter of fact. And Lord Hoffman doesn't dispute that. He accepts that at 24. The meaning of an English word is not a question of law because it doesn't have any legal significance. I'm speaking for myself, it's obviously true. The way we use words has nothing to do with what Parliament says or what the common law says. It's just the way we use words. Then Lord Reed says that a question of statutory construction is always a question of law. Well, again, that's obviously true. You have to read any legal text to understand what the text means, and that means not only what language it uses, but what its context is, and with statutes, what the purpose of a statute, and all that. And we have a lot of learning on how you go about that process, but again, both Lord Reid in Cousins and Brutus and Lord Hoffman here agreed that that's a question of law. And again, that seems to me to be obviously right. But Lord Reid says a third thing, and I'm not quite sure whether Lord Hoffman takes issue with it or not. He says that sometimes in statutes, ordinary words are to be given their ordinary meanings. So you construe the statute, you come across a word, X, and you conclude as a result of the text and the context and the purpose that X means what it ordinarily means. In that case, it was insulting. He comes to the conclusion that insulting wasn't being given by Parliament any special meaning. It was just being given its ordinary meaning. If that's your conclusion as a question of construction, you've gone through the question of law, the answer is it's given its ordinary meaning. Then Lord Reid says it's for the fact-finding tribunal, in that case the magistrates, to decide whether the primary facts meet this or not. And that's a pure question of fact, because it's for them to decide what insulting means. That's a matter of ordinary language, and you've already decided the question of law, which is Parliament didn't give it any special meaning. Now, it's not clear to me whether Lord Hoffman takes issue with that or not. If he does take issue with it, I'm not sure why. If he doesn't take issue with it, I'm not sure why he says that the observations are given a much wider meaning than the author intended. So,
My Lord, in my submission, he is addressing the argument that was put against him by counsel, which is recorded in 21, that
Right.
it would appear that effectively Cousins and Brutus was being relied upon as authority for the proposition that the words period throughout which he is so disabled physically and mentally that he cannot prepare a cooked main meal for himself were ordinary English words, and therefore the meaning of those words in the statutory context was a question of fact rather than a question of law. So, i.e., the point, it was being argued that the construction of the statute was a question of fact rather than law because they use ordinary English words. And what Lord Hoffman says is that is incorrect, partly because, and that would be to give Lord Reid's words a wider meaning than they actually have. So he then agrees effectively with Lord Reid, or he explains Lord Reid. He is not arguing against Lord Reid per se. And that is why at the end he concludes by saying we can't simply short circuit appeals on points of statutory construction by saying, well, they're an issue of fact because the words are ordinary English words.
okay, thank you.
The next authority, my lord, is Lord Carnwath's judgment in Pendragon, and Pendragon starts at 214. I'm sure the court is familiar. It was an appeal concerned with a VAT scheme, whether it infringed the EU principle of abuse of rights. Just by way of very brief introduction, the FTT allowed the taxpayer's appeal. The Upper Tribunal overturned that decision. The Court of Appeal restored the FTT's decision, and the Supreme Court unanimously allowed HMRC's appeal, with Lord Sumption giving the lead judgment and Lord Carnwath adding one of his own. And if we can pick up Lord Carnwath's judgment to 238, please. The proposition for which I go to this authority is that the position with the unified tribunal system is that it is more profitable to, or the court should adopt a more flexible approach to questions of what is a question of law and what is a question of fact, having regard to the specialist nature of the Upper Tribunal itself.
This passage has been discussed in subsequent authorities. I don't know if you're going to take us to them, but my recollection is that they confirm that the calm laws shouldn't be taken to be changing, for example, the Edwards and Burstone text.
And my lady, my submission is not that he changes the test.
Well, my point is it has been that the specific point that you've just referred to, I believe, has been the subject of subsequent comment.
I will look again over the over the short adjournment. He cites the Edward.
Possibly de Gaulle's, but I may be completely wrong.
I'm grateful, my lady. He cites refers to Edwards and Besser, I should say, in paragraph 45. He quotes from Lord Justice Jacobs. So I was on page 238, and by just below E, he quotes what Lord Justice Jacobs said. And there he said, "It is the tribunal which is a primary fact finder. It's also the primary maker of a value judgment based on those primary facts, unless it has made a legal error in that, in doing so, e.g. reached a perverse finding or failed to make a relevant finding or has misconstrued the statutory test, it is not for an appeal court to interfere." And sorry, that was the words from the High Court. And then Lord Justice Lloyd said something similar at paragraph 46. And then there's consideration of Procter and Gamble, and then said in paragraph 47. And it's in paragraph 48 that Lord Carnworth picks up the extended jurisdiction of the Upper Tribunal as a specialist tribunal. Something was recognised in the case of Jones. You see reference in paragraph 49, and reference to the white paper again after the quotation from Jones. And then it said, just below E, such a flexible approach was supported also by recent statements in the House of Lords in cases such as Moyner. So you see how Moyner has influenced Lord Carnworth there, and Lawson and Serco. In the latter case, Lord Hoffman had contrasted findings of primary facts with an evaluation of those facts to decide a question posed by the interpretation of the legislation in question. It says, whether one characterises this as a question of fact depends upon whether, as a matter of policy, one thinks it is a decision which an appellate body with jurisdiction limited to errors of law should be able to review. And certainly with my submission that when one is concerned with this novel piece of legislation, the decision as to whether there were, or how the legislation should be interpreted, was, as a matter of policy, a matter which an appellate body with jurisdiction limited to errors of law should be able to review. And in paragraph 50, you can see 4 lines from the bottom. Having found errors of approach in the consideration by the FTT, it was appropriate for them, i.e. the Upper Tribunal, to exercise their power to remake the decision. And then picking up at 51, against this background, it was unhelpful in my view for the Court of Appeal to identify the main issue as to whether the Upper Tribunal went beyond its proper appellate role. The appeal to the Court of Appeal under Section 13 was from the decision of the Upper Tribunal, not from the FTT. And their function was to determine whether the Upper Tribunal had erred in law. That was best approached by looking primarily at the merits of the Upper Tribunal's reasoning in its own terms rather than by reference to the evaluation of the FTT's decision. And then just above D on that page, by reference to what was said by Lord Hoffman, it may not be productive for the High Courts to spend time inquiring whether the difference between the two tribunals was one of law or fact or a mixture of the two. There may in theory be a case where it can be shown that the sole disagreement between the two tribunals related to an issue of pure fact, but such a case is likely to be exceptional, and I would interpose, and certainly on this case, that was not the grounds of the distinction between the FTT and the Upper Tribunal. In the present case, as Lord Sumption has shown, there was no significant issues of primary fact. The differences between the two tribunals related to the understanding of the abuse of law principle and their evaluation of the facts in the light of that understanding. The Upper Tribunal reached a carefully reasoned conclusion on law and fact. And certainly, in my submission, this is further support for the submission that one cannot say that the interpretation of the statute, because it uses ordinary English words, is a question of fact. It was open to the Upper Tribunal on the grounds it found to interfere with the FTT's decision. And that supports that point. There is if I can, there was one other reference in our skeleton argument to the case of SIP choice. It is recent Upper Tribunal authority. Unless you wish me to take it to you, it builds on the two judgments I've just identified rather than saying anything further. So, just concluding this point, my lord, I do say that applying those judgments to this case, the Upper Tribunal was concerned with the proper interpretation of a novel piece of legislation, in particular a statutory exception to the normal rules of day counting. It is correct that Parliament has used ordinary words, but it has used them in a particular way in the context of legislation with a particular purpose. And the meaning to be ascribed to that, the intention of Parliament, is, as I say, a question of law. And the Upper Tribunal was entitled to interfere on the basis that it did. That then, unless I can assist further, takes me on to ground 4. Is my lord content that I continue for the last 5 minutes on ground 4?
Yes, carry on.
So the ground 4 is that the Upper Tribunal erred in holding the moral obligations cannot be or cannot be part of exceptional circumstances. The court has already been shown the relevant statutory provisions. It is the exceptional circumstances which are beyond P's control that must prevent P from leaving. So that is the starting point in the statute, and that is common ground. So there must be exceptional circumstances in the first place, and it must be those which are the thing that prevents the person from leaving. Specific examples are then given of circumstances which may be exceptional. They are, of course, only examples and are not exhaustive. But I do say that those examples are all what I'd say are objectively verifiable. So the examples given are war, civil unrest, natural disasters, sudden or life-threatening illness or injury. They raise questions of fact as to whether there is a war, whether there is a natural disaster, and obviously the extent of it. The examples are not concerned with the reasonableness of people's reactions to those circumstances. In my submission, there is nothing in the statutory words to suggest that whether a person reasonably believes that the circumstances are exceptional is a relevant consideration. And I believe that to be common ground. My learned friend accepts that it is ultimately what he terms an objective question. If I can then turn to what the FTT decided, but pick it up because the relevant passages are quoted in the Upper Tribunal. Pick it up, please, at page 41 of the hearing bundle. And start at paragraph 41. And this is where the grounds of appeal gets slightly muddled because we are dealing with prevent here, but it is all feeds into the question of how these inhibitions play into exceptional circumstances. So the word prevent can encompass all manner of inhibitions, physical, moral, conscientious or legal, which cause the taxpayer to remain. Then we can skip the following paragraphs, which are to do with the internal inconsistencies, and I'll come back to those. And then pick up, please, the Upper Tribunal's reasoning on this point at page 43 of the bundle. And it's paragraph 50 of the Upper Tribunal's decision. Paragraph 50, the Upper Tribunal sets out the cumulative requirements. Paragraph 53, there was reference by my learned friend to the criminal law test of duress. There was reference in the FTT to that. And the suggestion that the tribunal was concerned with whether a person of reasonable firmness sharing the characteristics of the person in question, would have responded in the same way. And then halfway through 53, this was in terms of submission, the paragraph 22.4 requirements are similar to those for reasonable excuse, where the starting point is the position of the particular taxpayer in the course of his oral submissions. However, Mr. Kessler wisely withdrew his analogy with duress. But what he certainly did do was to press the analogy with reasonable excuse. And then paragraph 54, the tribunal address why reasonable excuse is not a relevant analogy. They do that at 1 by reference to the lack of any word reference in the statutory language to reasonably or reasonable excuse. At 2, make the point that the examples of exceptional circumstances are objectively verifiable. They do not depend on the taxpayer's reasonable belief. And 3, this is the support for the government's response to the consultation on the SRT, and this is the phrase that I said to my Lord Justice New I would return to. The guidance said it was looking to introduce a statutory definition of tax residence, statutory residence test that is transparent, objective, and simple to use, and therefore a test of reasonable excuse would not hit those, would not satisfy the purpose of the legislation. If I can just pick up before the short adjournment, please, my Lord, whilst I have the point. If we go to paragraph 71 on page 47. Actually, it's paragraph 70 itself, making the point which is common ground, that it is the exceptional circumstances which must prevent the person from leaving. Paragraph 71 quotes again what the FTT said at 150. 72, however, the statutory question is not whether a person is prevented by an inhibition from leaving the UK, it is whether exceptional circumstances prevent the person from leaving. The FTT sought to deal with this by saying in the same paragraph, and there is the quotation there. And that really gets to the heart of the issue on this ground, which is that it was suggested that because a taxpayer thought it was necessary to be present, that was sufficient to satisfy the statutory test.
The statutory test of prevention, which is what all this is about.
We see prevention is, yes, this is in the context of prevention. Yes.
Yes.
But what one sees over the page, my Lord, just to anticipate the point, is when we get to 77, paragraph 77 over the page, the FTT saying moral obligations and obligations of conscience, including those arising by virtue of a close family relationship, can qualify as exceptional circumstances, and those obligations may be strong enough to prevent a taxpayer leaving the UK. So is the FTT's position that the moral obligations could themselves qualify as exceptional circumstances. The previous passage I just referred to was explaining why it was not was to do with prevent and the reasonable excuse test in that context.
Yes. Right.
Right.
Okay, we'll adjourn now until 2 o'clock.
Court rise, please.